Good morning. Today, we will be presenting on medical negligence and the changing role of Bolam. Let us begin with a brief introduction of our team.
My name is Kamila Lakshmi.
My name is Muhammad Zarif bin Abdullah.
And my name is Krisha Damani.
My name is Xiyu Chen.
My name is Ku Yan Yun.
My name is Dayanku Aisha Zahra.
The main question we will be discussing is the Bolam test still the governing test for medical negligence? This question focuses on whether Bolam still determines the standard of care for medical professionals, especially in matters of treatment and diagnosis. To answer this, we will compare the position in England and Wales and Malaysia and examine how far Bolam remains relevant in both jurisdictions today. Before the Bolam test, courts faced a difficult problem. How should judges decide whether a doctor had acted negligently? After all, courts are experts in law, not medicine. So, how could a court decide whether a surgeon made the wrong move, or whether a treatment choice was unacceptable, or whether a doctor had fallen below the proper standard? Should the court judge the doctor by ordinary common sense? Should the patient's bad outcome automatically mean negligence? Or should doctors be judged according to the accepted medical practice at the time? To understand how law answered these questions, let's look at the landmark case that established the Bolam test, Bolam and Frian Hospital Management Committee. Before we enter the courtroom, let's briefly look at what happened in Bolam and Frian Hospital. Mr. Bolam was injured and suffered fractures as a result of alleged medical malpractice. He subsequently sued Frian Hospital for medical negligence, but the case was not simply about whether he was injured. The real legal question was whether the doctor's actions fell below the standard expected of a competent medical professional at that time. So, now, let's see how both sides argued their case in court.
Your Lordship, my client, Mr. Bolam, underwent electroconvulsive therapy at the hospital. He was not given muscle relaxants or restraints during the treatment, and as a result, he suffered from serious fractures. We argue that the hospital failed in its duty of care. A patient should be protected from unnecessary risk, and in this result, the precautions taken were not enough. So, the question before the court is simple. Did the doctor fall below the proper standard of care?
Your Lordship, the hospital denies negligence. All the time, not all doctors use muscle relaxants or restraints for this treatment. The doctor followed a practice that was accepted by a responsible body of medical professionals. Medicine is not always black and white. Different doctors may choose different accepted methods. So a bad outcome does not automatically mean negligence. So the real question is not whether another doctor would have done it differently, but whether this doctor acted according to accepted medical practice.
Order. Having heard both sides, the court must decide the standard for medical negligence. A doctor is not negligent if they act in accordance with a practice accepted by a reasonable body of medical opinion. The court should not replace medical judgment with the judge's personal opinion. Even if other doctors may disagree, the doctor will not be negligent if the practice is supported by responsible medical professionals. Therefore, in this case, the hospital is not liable for negligence. The principle became known as the Bolam test. In simple terms, professional medical opinion sets the standard, not the judge's personal view.
The House of Lords confirmed this twice. In White House in Jordan 1981, a baby suffered brain damage during a forceps delivery. The Court of Appeal suggested that an error of clinical judgment could itself be negligent. The House of Lords disagreed. Bolam applied. An honest professional disagreement is not negligence. Then, in Maynard and West Midlands RHA, Lord Skrama extended Bolam to diagnosis. 2 consultants performed an operation rather than wait for test results. The patient was harmed. The trial judge preferred one expert over another and found negligence. The House of Lords reversed this. A judge's preference for one body of medical opinion is not sufficient. If responsible opinion supports the defendant, that is the end of it. By 1984, the position was clear. Courts deferred almost entirely to the medical profession. As Doolan argues in his 1995 article, Doctor Knows Best, articles stated that English judges helped reduce questions about what the law ought to be to questions about what doctors actually do or think. This is a delegation of judicial responsibility that made it very difficult for patients to challenge substandard care.
That deference attracted criticism. The obvious problem is, what if the entire body of expert opinion is simply wrong? Therefore, in the case of Bolito and City Hackney Health Authority addressed this. A 2-year-old Patrick Bolito was admitted with breathing difficulties. A registrar failed to attend when called. Patrick suffered a cardiac arrest and brain damage. The hospital's defense relied on expert pediatricians who said they would not have intubated even if they have attended. Under a pure Bolam analysis, that expert support should have ended the inquiry. However, the House of Lords said, not quite. Lord Brow-Wilkinson confirmed Bolam remains the test, but added a qualification. A court is not bound to accept expert opinion just because it comes from professional. The opinion must be logically defensible, and the experts must have weighed the relevant risk and benefit, and their conclusion must withstand logical analysis. If it cannot, the court can reject it. And on the facts, the health authority succeeded. The decision not to intubate was genuinely defensible. But the principle was established. This judicial qualification introduced in Bolito attracted significant academic attention. One influential discussion is found in the journal article, Bye Bye Bolam, A Medical Litigation Revolution, by Margaret Brazier and Jose Miola. The authors examined whether Bolito marked a genuine shift away from the traditional deference embodied in Bolam. They argued that Bolito gave courts a greater supervisory role by allowing judges to reject professional opinions that cannot withstand logical scrutiny. However, they also questioned whether the decision truly revolutionized medical negligence by law, noting that courts have continued to exercise this power cautiously and remain reluctant to challenge mainstream medical opinion. This leads to why the standard after Bolito is sometimes called Bolam with a gloss. Professional opinion still governs, but it must be defensible, not just asserted. So, the Bolam test survives, but Bolito ensures it cannot be used as a rubber stamp. The court defers to the profession, but retains the final word on whether the deference is earned. Thank you.
Now, I'm going to talk about the Montgomery shift in medical negligence law in England and Wales. Specifically, how it changed the law on medical consent and advice. This shift is important because it represents a move from a doctor-centered approach to a patient-centered approach in medical decision-making. The key case here is Montgomery and Lanarkshire Health Board in 2015. The claimant, Mrs. Montgomery, was a diabetic woman giving birth under a care of an obstetrician. Because she was diabetic, her baby was likely to be larger than average. This increased the risk of a complication called shoulder dystocia, where the baby's shoulders get stuck during delivery. The risk was known to the doctor, but the doctor did not tell Mrs. Montgomery about it. The doctor also did not inform her about the option of a cesarean section, also known as a C-section. Mrs. Montgomery later said that if she had known about the risk, she would have chosen a C-section instead. During delivery, shoulder dystocia occurred and her baby suffered with serious injury. Hence, she filed a claim under negligence. Before this case, medical negligence, including consent issues, was largely governed by the Bolam test from Boland and Friend Hospital Management Committee. Under this approach, a doctor was not negligent if they acted in accordance with a responsible body of medical opinion. In the context of informed consent, this meant that doctors themselves largely decided what risk to disclose and how much information should the patient receive. So, the focus was very much on professional judgment. This is often described as a paternalistic model, where doctors decide what is best for the patient. However, over time, this approach was criticized. The main issue was that patients were not truly involved in decision making. Doctors might decide not to mention certain risks because they think that they are rare or they are not medically important. However, what is small medically may still be extremely important to a patient. So, the problem is that patients were not truly able to make informed decisions about their own bodies. In that sense, it can be seen as unfair because it assumes doctors always know what is best, even when their personal values differ between patients. However, this changed in 2015 when the Supreme Court followed Montgomery. The court rejected the idea that Bolam should be applied to informed consent. Instead, it introduced a patient-centered test. Now, doctors must disclose any material risk of the treatment and any reasonable alternative treatments. So, what is considered a material risk? A risk is considered material if a reasonable patient would consider it as important, or the doctor knows that the particular patient would likely attach importance to it. So, the focus is no longer on what doctors think is important. Instead, it's about what the patient would want to know in order to make their own decision. This case represents a clear shift in legal philosophy. Under Bolam, doctors were the decision makers regarding disclosure, but under Montgomery, the patients become the decision maker about whether to accept risk. So, the law moves from medical paternalism to patient autonomy. To conclude, the Montgomery case significantly changed the law on medical consent in England and Wales. We now have a clear distinction. For treatment and clinical judgment, Bolam and Bolito test applies, and it is the doctor-centered standard. However, for medical advice, consent, warnings and risk disclosure, Montgomery applies. This is the patient-centered standard. Overall, this reflects a modern legal approach that prioritizes patient autonomy and informed decision-making over medical paternalism.
Building on the developments discussed by my group members, the current position in England and Wales is that although Montgomery changed the law on informed consent, the Bolam test remains highly relevant in matters of diagnosis and treatment. This can be seen in the recent Supreme Court case of McCulloch and Forth Valley Health Board in 2023. In this case, the patient suffered from infective endocritis and later on passed away. The claimant argued that the doctors should have discussed NSAIDs, which are common anti-inflammatory painkillers such as ibuprofen and aspirin, as well as alternative treatment options. However, the doctors considered that treatment to be clinically inappropriate and therefore did not discuss it with the patient. The Supreme Court held that the doctors were not negligent. The court stated that whether a treatment qualifies as a responsible or reasonable alternative is a matter of professional medical judgment. Therefore, the Bolam test is refined by Bolito, remained the appropriate standard. The significance of McCulloch is that it confirms that Bolam continues to act as a filter, meaning if a reasonable, responsible body of medical opinion considers a treatment clinically inappropriate, doctors are not required to present that option to the patient. Only options that pass this clinical threshold need to be disclosed. However, this approach has attracted academic criticism. Louis Austin argues that McCulloch effectively restores the influence of Bolam by allowing doctors to decide which treatment options are presented to patients in the first place. She suggests that this may limit the patient-centered approach established in Montgomery. Overall, the current position is that Bolam has not been replaced. Instead, the law now operates as a dual test system. Bolam governs diagnosis, treatment, and the identification of reasonable treatment options, while Montgomery governs the disclosure of risk and informed consent. Therefore, Bolam remains a central governing principle in medical negligence, although its role is now more limited than before.
Looking at both English and Malaysian jurisdictions, they adopted the Bolam test to govern the standard for cases of medical negligence. At present, the two jurisdictions have developed in two different directions. In England, the Bolam test remained but narrowed through case laws such as Bolito and Montgomery. According to Bolito, Doctors cannot escape liability simply through support of other expert opinions. The House of Lords declared that courts must undergo logical scrutiny, not just blindly accepting medical opinion. Following Montgomery, the Supreme Court completely departed from the Bolam test and instead adopted a patient-focused standard by shifting the legal standard of risk disclosure from what a reasonable doctor would share to what a reasonable patient would consider significant. Despite the developments of such case laws, the primary standard for diagnosis and treatment in England is still the Bolam test. The key difference lies in how each jurisdiction departed from the Bolam test.
Originally, Malaysia adopted the Bolam test as the primary standard for assuming medical negligence. One of the earliest examples is Shin Kiao and Government of Malaysia in 1967. In this case, a patient who was known to be allergic to penicillin was nevertheless given a penicillin injection. The Privy Council applied the Bolam test and held that the doctor was negligent because the treatment fell below the standard expected of a competent medical practitioner. This case was the first to affirm the use of the Bolam test in Malaysia in Malaysian medical negligence law. Another important case is Khao Nan Seng and Nagama in 1982. The plaintiff suffered a broken leg and was treated with a plaster cast that was applied too tightly. Despite complaints of severe pain, the doctor failed to take appropriate action, and which eventually led to the leg becoming gangrenous. Another important case is Khao Nan Seng and Nagama in 1982. The plaintiff suffered a broken leg, which was treated with a plaster cast that was applied too tightly. Despite complaints of severe pain, the doctor failed to take appropriate action. Eventually, the leg became gangrenous and had to be amputated. The federal court applied the Bolam test and found the doctor negligent. The court held that competent doctors would have recognized the risk of impaired blood circulation and responded appropriately to the patient's complaints. This case demonstrated that although the Bolam test protected doctors who followed accepted practices, it would not shield conduct that clearly fell below professional standards. The next major development came from Australia in the case of Rogers and Whittaker. In this case, the patient underwent eye surgery and was not informed of a rare complication known as sympathetic ophthalmia. Although the risk was very small, the complication occurred and resulted in near total blindness. The Australian High Court held that doctors have a duty to warn patients of material risks associated with treatment. A risk is considered material if a reasonable patient would attach significance to it, or if the doctor knows that the particular patient would regard it as important. This decision shifted the focus from what doctors think patients should know to what patients themselves need to know in order to make informed decisions. The influence of Rogers and Whittaker reached Malaysia through the landmark federal court case of Fu Fiona and Dr. Su Fuk Mun in 2007. The plaintiff became paralyzed following spinal surgery and claimed that she had not been adequately informed of the risks involved. The federal court held that the Bolam test should not govern cases involving a doctor's duty to advise patients about material risks. Instead, the court adopted the reasoning in Rogers and Whittaker, emphasizing patients' autonomy and informed consent. The court stated that patients have the right to decide whether to undergo treatment after being informed of the relevant risks. Following Fu Fiona, many believe that the Bolam test had been completely replaced in Malaysia. According to a journal article by Hidayani and Hatta, the Bolam case had been deemed irrelevant by academics in Malaysia following the decision in Fu Fiona, due to its overly paternalistic focus in protecting the medical profession. This decision established that courts, rather than medical professionals, have the final say in determining whether sufficient information had been provided to patients. This marked a significant shift from a doctor-centered approach to a patient-centered approach in relation to disclosure of risks and informed consent. Subsequent cases continued to apply the Rogers and Whittaker approach in matters involving advice and disclosure. For example, in Dominic Putucherry and Dr. Gun Siu Fong, the court relied on Fu Fiona, which followed Rogers and Whittaker, and rejected the Bolam test. Similarly, in Dr. Ismail Abdullah and Po Hui Lin, the court applied the Roger and Whittaker test and held the only material risks needed to be disclosed to patients. These cases reinforced the importance of informed consent and patient autonomy. The uncertainty surrounding the status of the Bolam test, whether it was fully rejected or limited, was addressed in the federal court case of Zul Hasima and Dr. Kupu Velumani in 2017. The issue was whether the Bolam test or the Roger and Whittaker test should apply in medical negligence cases. The federal court clarified that these two tests serve different purposes. The court held that the Bolam test continues to apply to matters involving diagnosis and treatment, while Rogers and Whittaker approach applies to the duty to advise patients of material risks. Today, Malaysia adopts a dual approach for diagnosis and treatment. Courts apply the Bolam test. The standard of care is determined largely by accepted medical practice and professional opinion. And for advice, disclosure of risks, and informed consent, courts apply the Rogers and Whittaker and Fu Fiona principles. The focus is on what a reasonable patient would consider significant when making treatment choices. Therefore, the Bolam test remains alive and relevant, but however, its scope is now limited.
Now, let's have a look at the current Malaysian position of medical negligence. In the recent case of Tan Sri Datuk Sri Muhammad Hussein bin Abdul Hamid and Gleneagles Hospital. In this case, the patient suffered a rare injury to his popliteal artery during a knee arthroscopy. The issue was whether the surgeon was negligent during the procedure and whether he had failed to properly warn the patient about the risk. Overall, this case shows the current position in Malaysia. The Bolam test is still used for matters involving clinical skill, diagnosis, and treatment. However, for risk disclosure and informed consent, Malaysian courts follow a patient-centered approach based on Rogers and Whittaker, similar to Montgomery in the UK. The case also confirmed that hospitals can be held responsible for negligence within their facilities, even if the doctor is an independent contractor. This provides additional protection for patients. Therefore, the current position in Malaysia is that Bolam remains relevant, but its role is limited. It governs treatment decisions, while patient autonomy governs consent and disclosure of risks.
The Bolam test outlines that as long as a doctor meets the standard of a reasonable doctor of the same expertise, they would not be found liable for negligence. On the other hand, Fu Fiona represented that courts must determine if the material risks and advice provided to patients were sufficient. This highlights the importance of informed consent to patients, hence shifting towards a more patient-centered approach. The Bolam test had protected the legitimacy of medical expertise, as courts were not equipped with the technical and medical knowledge to evaluate medical procedures. However, the paternalistic approach to Bolam had allowed doctors to set the standard for medical professions itself. Currently, a fragmented standard has been established with a dualistic approach to medical negligence cases, where Fu Fiona is only applied in cases of the disclosure of risk and consent, but the Bolam test continues to apply for diagnosis and treatment. To conclude, though the Bolam test was originally the dominant standard, it is no longer absolute in governing all aspects of medical negligence in Malaysia. The landmark decision in Fu Fiona introduced a patient-centered approach for informed consent by adopting the principles from Rogers and Whittaker. Additionally, the federal court in Zulhasnimar ultimately clarified the law by preserving the Bolam test for diagnosis and treatment, while reserving the Rogers and Whittaker test for disclosure of risks and consent. As a result, the current Malaysian position balances professional medical expertise with the patient's right to make informed decisions regarding their own healthcare. The same development can be observed in England, where the Bolam test was progressively narrowed through Bolito and eventually displaced by Montgomery, which demonstrated the importance of medical risk disclosure. In current times, both England and Malaysia originally adopted the Bolam test and continue to apply it for diagnosis and treatment. Therefore, the law surrounding medical negligence has evolved to not only respect expert doctor opinions from the Boland test, patient autonomy is no longer disregarded as consent has become important in Malaysia and England.
Thank you for watching.